Within this module, we will discuss end-of-life issues that may need to be addressed by EMS providers. To clarify, this module will not discuss advanced directives like living wills and do not resuscitate orders, which were covered in a previous module. Rather, this module looks more at the legalities of limiting, withholding, or terminating resuscitation activities. With this purpose in mind, once completed with this module, you should be able to discuss the concept of limited resuscitation efforts, identify criteria for withholding resuscitation, explain when to terminate resuscitation activities, and discuss organ donation as an end-of-life patient decision or option. This module addresses legalities related to end-of-life issues as applied to paramedics. In providing this information, nothing in this presentation should be construed as legal advice. Rather, the information provided is merely a broad overview of this legal subject as denoted within the National Paramedic Educational Standards. Please be aware that every state has different laws that impact EMS agencies and providers, and these laws may change over time by application of legislative action or court decisions. Federal, state, and local laws and other legal provisions not discussed within this presentation may also impact EMS agencies and providers. Additionally, information that was current or applicable at the time this presentation was produced may not be at the time you are watching this presentation, and new laws may have been added as well. Lastly, the legal topics and doctrines discussed within these presentations are not the totality of all laws that apply to EMS agencies and providers. There are numerous other laws and provisions that impact diverse aspects of providing EMS. If you or any other EMS provider has questions related to the laws that apply within the realm of providing EMS, additional guidance and assistance should be obtained from a licensed attorney within your area who has subject matter expertise in the specific area of law in question. While we already stated this module is not about advanced directives, it is impossible to discuss the withholding, limiting, or discontinuation of resuscitative efforts in the field environment without recognizing the impact of advanced directives and other related topics. To begin, it may be necessary to limit, withhold, or discontinue resuscitative efforts based upon the wishes of a healthcare proxy. Simply stated, a healthcare proxy is a person who acts on behalf of a patient who cannot express his or her own wishes. Some states use the term healthcare proxy in lieu of medical power of attorney. Regardless, the appointment of a healthcare proxy or medical power of attorney is often accompanied by a legal process and paperwork as defined within the respective state. Within Wisconsin, this proxy power is formalized in State Statute, Chapter 155, which governs the requirements for executing a power of attorney for healthcare. Many states, Wisconsin included, do not require a patient to be unconscious for a healthcare proxy, agent, or power of attorney to be effective. A determination or finding of incapacity may be enough to allow a proxy to stand in the place of the principal, the patient. The duties and obligations of a healthcare proxy can vary by state, so it is important to be familiar with the laws that govern the practice of EMS within your state. Having medical director protocols in place to assist with navigating these scenarios is a must. Given a properly executed and presented healthcare proxy document, resuscitative efforts may be limited by the patient's healthcare agent or proxy, just as if the decision were made by the patient him or herself. Another important driver in end-of-life care can be what is known as medical orders for life-sustaining treatments or physician's orders for life-sustaining treatments. These are standing orders issued by a patient's physician, typically, that define the type of care the patient should receive if he or she becomes incapacitated, meaning the patient no longer has decision-making capacity. Rather than being limited in focus, like a do not resuscitate order or a living will, these MOLST or POLST documents often include treatment plans for patients suffering from various ailments and typically recognizes a need for palliative and other care beyond the simple withholding of CPR. Intubation, feeding tubes, antibiotics, pain control, and other potential treatments are commonly recognized within these documents and may be mandated or withheld depending upon the circumstances. These documents are commonly developed in conjunction with the patient while he or she has capacity to make healthcare decisions, and they are designed to apply to a broad swath of healthcare providers, not just physicians and nurses in a hospital. Whether MOLST or POLST documents are recognized within a particular state is a function of that state's law, and not all states recognize MOLST or POLST documents generally or in all settings. Within Wisconsin, for example, there is no formal statute governing most or POLST documents. The closest thing is a declaration to physicians document, a living will, as defined within state statute Chapter 154. Physician orders are still utilized within hospitals and other formal healthcare facilities, but those orders rarely are applied beyond the walls of those particular facilities. Just as mentioned previously with healthcare proxies, paramedics must be familiar with the different types of advanced directives defined by the laws within their respective state and ensure familiarity with agency protocols on how to handle those documents and their provisions in the field. Years ago, it was common practice for EMS to provide full resuscitative efforts to virtually all patients who appeared to be even remotely viable. In more recent times, this zealous approach to resuscitation has been somewhat eroded in light of data related to the futility of such efforts in conjunction with consideration for the patient's wishes. We recognized in an earlier module that patients have the right to self-determination and may withhold consent for treatment in many instances where death may very well be a likely result. In light of current attitudes recognizing the right of people to die with dignity, when faced with the natural process of dying, imposing the will of an EMS provider to resuscitate against a patient's wishes is not only ethically problematic, it could actually give rise to a civil wrong or illegal criminal behavior. Therefore, the first consideration in whether to withhold resuscitation centers on the patient's individual wishes. If the patient is unable to communicate with the EMS crew at the time of his or her potential demise, advanced directives such as do not resuscitate orders, living wills, healthcare power of attorneys, and medical orders for life-sustaining treatments should govern what interventions, if any, are performed. Remember as well from your EMT education that futile resuscitation efforts are not medically or ethically indicated. If signs of obvious death are present, resuscitation should be withheld. Obvious signs of death include rigor mortis, also known as postmortem rigidity, whereby the limbs stiffen and no longer bend as they did when the person was alive. This can occur within 3 to 4 hours of death in humans. If left long enough, this rigidity will go away, but that usually takes 36 hours or more, during which time the internal temperature of the body will decrease to match the ambient temperature of the environment, making the body feel cold. Dependent lividity, also known as liver mortis, hypostasis, or sugillation, occurs when the heart stops circulating blood throughout the body and gravity takes over, causing the blood in the body to pool in the lowest areas of the body to which the blood can flow given the position of the body. This occurs somewhat rapidly over the first hour or two after death, with the skin appearing bluish and blotchy in these lower regions of the body. Where pressure is exerted, such as where a body may be lying on a floor, the blood is pushed away, resulting in pale patches surrounded by this darker discoloration. Within the first 5 to 6 hours, pressing on an area of dependent lividity will cause the skin to blanch or turn pale. After about 10 to 12 hours, pushing on a discolored region no longer alleviates the discoloration. Putrefaction marks the beginning of organic decomposition of the body. The time frame over which putrefaction occurs can fluctuate given numerous environmental factors in addition to the condition and age of the person at the time of death. Some signs of putrefaction include swelling or bloating of the abdomen, skin blisters, sloughing skin, blackening of the skin, and noxious odors. These signs become even more pronounced over time and slowly progress into decomposition of the body. Needless to say, a body in such a state is never a candidate for resuscitative efforts. Lastly, if there is evidence of a non-survivable injury, resuscitative efforts are contraindicated. It has been said that a traumatic death is a traumatic death, and if the patient is not on an operating table at the time of the traumatic incident, there is often very little EMS can do for the patient. Evidence of such non-survivable injuries include decapitation, dismemberment, being burned beyond recognition, significant blast injuries, and exposed brain matter, to name a few. Your agency should have protocols in place that help EMS providers determine when a patient is not a candidate for resuscitation, given what should be signs of obvious death. As a paramedic, you must be familiar with your local protocols and be prepared to follow them when faced with the decision to withhold resuscitation based upon obvious death criteria. If need be, do not hesitate to contact medical control for guidance. Remember your ALS toolkit and apply a 3-lead and see if the patient is asystole, which can be further evidence to bolster your suspicion that the patient is irretrievably dead if coupled with some of these other signs of obvious death. Ultimately, if death is not necessarily obvious, it may be necessary to begin resuscitative efforts while also contacting medical control for direction. Based upon the circumstances, medical control may direct the crew to cease resuscitative efforts. When functioning as an EMT at the BLS level, once CPR is started, it often cannot be stopped until the patient is transported and a physician at the emergency department terminates the resuscitation. As a paramedic, you will find that many agencies have protocols in place that allow for resuscitative efforts to be discontinued in the field. Data and research has shown that some patients are statistically unlikely to be resuscitated, and even if they are, the likelihood of returning to a neurologically intact state is often minimal. Yet, despite this data, EMS agencies would routinely attempt resuscitation, transport lights and siren, and present the patient to an emergency department at significant risk to the crew and great financial cost to the system, the dead patient's estate, and potentially taxpayers. To help systems weigh the risks of ongoing resuscitative efforts against the potential benefits with a focus on data-driven decision-making and ethical principles, the National Association of EMS Physicians published a position statement in 2011 on the termination of resuscitation efforts for patients of non-traumatic cardiopulmonary arrest. If a patient arrest was not witnessed by EMS, no shockable rhythm was identified, and EMS is unable to obtain the return of spontaneous circulation, it may be prudent to terminate resuscitative efforts. This assumes, as recognized by the American Heart Association, that ACLS resuscitation protocols were followed, and there are no mitigating factors that may support prolonging resuscitative efforts, such as patient hypothermia or an arrest due to a drug overdose. How long resuscitative efforts must be performed is not defined by the NAEMSP statement, which means the decision falls upon local medical control and approved standing orders or protocols. It is not unusual for protocols to require the paramedics to contact medical control for guidance before discontinuing resuscitation efforts. Additionally, EMS agencies must have protocols in place that address the management of the deceased patient and adequate supports for the patient's family, friends, or others impacted on scene by the patient's death. Similarly, the NAEMSP also has a position statement on the termination of resuscitation for adult traumatic cardiopulmonary arrest patients. Published just a year later in 2012, the statement holds that EMS systems should have protocols in place that allow EMS providers to terminate resuscitative efforts for certain adult patients in traumatic cardiopulmonary arrest. If the EMS crew has been providing minimally interrupted CPR and the patient still shows no sign of life and there is no return of spontaneous circulation, at some point it would be prudent to discontinue resuscitative efforts. The position statement recognizes past guidance that indicated CPR should be provided for at least 15 minutes prior to the termination of resuscitative efforts, but that number was not based upon clear data and evidence. Thus, a longer or shorter period of time may be appropriate based upon the circumstances and local protocols. One of the ethical issues that often arises with regard to the termination of resuscitative efforts is that of organ donation and whether or not a patient should continue to receive resuscitative efforts not to actually save the patient, but to keep his or her organs perfused as best as possible to facilitate organ harvesting for donation. Needless to say, this is a discussion that an EMS agency should have before faced with such a situation, and a protocol needs to be in place to provide guidance for EMS crews in the field. Along somewhat similar lines, some states may even impose an affirmative duty on EMS providers to assist with the organ harvesting process to a certain extent. As an example, Wisconsin Statute 156.06 sub 12 requires any law enforcement officer, firefighter, EMS practitioner, EMR, or ambulance service provider to make a reasonable search of any individual reasonably believed to be dead or near death for a record of gift, a record of refusal, or other information identifying the individual as a donor of an anatomical gift. If the patient is transported to the hospital, the EMS provider is obligated to notify the hospital of the patient's record of gift or record of refusal. While failing to follow this law does not give rise to civil or criminal liability in the state, the EMS provider could still be subject to administrative sanction for failing to make this search. If a resuscitation attempt is not made or is discontinued and the patient is not transported by the EMS crew to a hospital, what happens to the body? The answer may depend upon the circumstances and the state in which you practice. As some examples, if the patient is the victim of a crime, died in a car accident, or committed suicide, the body and the area around it becomes part of a crime scene, and removing or disturbing the body and the scene any more than necessary can be problematic for law enforcement. Absent circumstances that would give rise to law enforcement concerns, some protocols may require the EMS crew to contact the local coroner, medical examiner, law enforcement, or maybe even a local funeral home or mortician. Some protocols may allow the EMS crew to leave the body in the care of family members who would then make further arrangements for the body by presumably contacting a funeral home. If the deceased patient is in a nursing home or is receiving hospice care, plans for the disposition of the body are probably already in place, and an EMS crew forcing the body to be moved could actually be disruptive. Some states, like Wisconsin, even have laws governing the disposition of human remains during states of emergency relating to public health. The terms of Wisconsin Statute 157.055 sub 2 Parent B even allows a public health authority to take possession and control of human remains during a public health state of emergency. Another consideration for EMS crews is how the EMS crew leaves the body and scene once the crew is prepared to leave the scene. This is especially important if the body will be remaining on scene with family members of the deceased. If resuscitative efforts were started, does the EMS crew leave all of the trash and consumable medical devices strewn all over, or should the EMS crew clean up the scene and, to the extent possible, the patient? All of these considerations must be addressed by local agency protocols, and you, as the paramedic, will be responsible for not only knowing these protocols, but complying with them. While not the most pleasant topic, paramedics must be prepared to address questions surrounding death, dying, resuscitation, patient rights, family expectations, and legalities surrounding end-of-life issues. Now that you are completed with this module, you should now be able to discuss the concept of limited resuscitation efforts, identify criteria for withholding resuscitation, explain when to terminate resuscitation activities, and discuss organ donation as an end-of-life patient decision or option. As in most EMS activities, the laws governing end-of-life issues that impact EMS can vary considerably from state to state and jurisdiction to jurisdiction. Be aware of the laws that apply in your particular area of practice and ensure familiarity with your agency's protocols regarding EMS calls pertaining to these end-of-life matters. This presentation was prepared by Waukesha County Technical College in Pewaukee, Wisconsin, and is distributed with an attribution non-commercial share-alike 4.0 International Creative Commons license. Copyright 2019 Waukesha County Technical College. For information on WCTC's numerous fire and EMS educational offerings, please visit us online at wctc.edu.